The impression I'm getting is that there's several concerns that you're worried about, and so you're raising those up at this time. So the purpose of today's hearing is to look at a summary of what happened on November 21st. So the court made some rulings on November 21st, specifically about parenting plan. And we're here to have that summarized and make sure that the proposed summary that Mr. Foley presented is accurate of what the court ordered on that particular time. So if there's new concerns that are coming up or boiling up, then you'd have to file some type of motion to address those specific motions. For example, you indicated that there's another woman that's living with Mr. Torres and concerns about criminal convictions and the like. That if that's a concern, then you'd have to file a motion and allow Mr. Foley notice so he could respond to it. So today's purpose of our hearing is to focus on this presentation of this order, whether the summary presented by Mr. Foley is accurate or not accurate according to what the court ruled on November 21st. Does that help?
Yes.
Okay. Well, as far as this proposed order, the parenting plan, what other areas do you feel that it's not accurately portrayed what the court ordered?
I'm concerned that Luciano Torres has to spend 5 days in jail for his traffic ticket he got on July 2nd. I found this information out, and it was not brought to my attention that he was going to be having Mason while he was spending his 5 days in jail, which means Carly Partain, the woman living with him, would be having my daughter when he does not have her. That is my concern, that he's not addressing to the courts, that he has jail time.
Okay. So any other concerns about the proposed parenting plan that was submitted?
No, I don't believe so.
Okay, I've signed off on that proposed parenting plan, so we'll get that.
Your Honor, if I could just raise one issue. Ms. Wolski did have, I think, a very good suggestion at the beginning of this. As the court's aware, there had to be a third party available for the exchanges, the pickups and the drop-offs. And she suggested Mr. Torres pick the child up at daycare Friday afternoon. That solves the pickup problem. The drop-off is still the issue. That's one of the reasons he had this woman actually come up from Texas so that she could do the third-party drop-offs. That's not going to last forever, Your Honor, and it's not a significant other live-in relationship. It was just a matter of meeting the conditions to get around the protection order. So my suggestion is to take Ms. Wolski's recommendation and go a little bit further and just do the return to daycare on Monday, as opposed to return on Sunday night. Now, that should only be the case, I think, for about another 60 days, because Judge Warning, the protection order that he entered, he made it effective for 90 days. So to avoid the issue with having a third party do the transport, we've solved the Friday pickup, but my suggestion is just to return the child to daycare on Monday, and I think that will solve the problem.
So you're looking at paragraph number 12 of the proposed parenting plan?
That's correct.
So Ms. Wolski, looking at paragraph 12, here it indicates the child will be exchanged for parenting time, picked up and dropped off, daycare or school if not in session. So that's where the exchange would occur at daycare. And if not, then if it's not in session, then it would be at the Hall of Justice. So, Mr. Foley, what are you making a proposal to change that according?
Well, yes, just to do the drop off at daycare, and that would occur Monday morning. So,
so just as it says on the first line, the child will be exchanged for parenting time at daycare.
Yes.
Okay, Ms. Wolski, on that paragraph number 12, basically it's Mr. Foley is proposing that it just read the child will be exchanged for parenting time at daycare, and if it's not at session, then at the Hall of Justice.
So are we stating that he's taking her to daycare on Monday? Is that what you're proposing?
I think that's the proposal by Mr. Foley.
Right.
I have a third party person doing the pickups or for me at 5 p.m. or 8 p.m. on Wednesdays and every other Sunday at 5 p.m.
Okay.
I don't think that I need to have him take her to school on Monday when I have this side figured out.
Okay.
And we had our hearing. It was Thanksgiving weekend. I didn't have a third party person at that time, and which now I do, and she is doing the drop offs. Everything is going well with that.
Well, actually, there was an issue, Your Honor, and that's why I proposed it, but I'll defer to the court.
Yeah, so as far as what the court ruled on November 21st, the court ruled that the parenting time of Mr. Torres would be the Friday, the first, third, and fifth weekends, Friday from 5 p.m. until Sunday at 5 p.m. Mr. Foley's proposal extends that an additional overnight, which the court did not order. So I'm going to leave the transportation arrangements as indicated, that the child will be exchanged for parenting time at daycare or school, and if it's not in session, then it would be at the Hall of Justice. So that would take care of the Sunday, and that it also indicates that a third party will provide the transportation for Mr. Torres. So I'm going to leave that as is.
Thank you.
Okay, so I've signed off on that parenting plan.
So, Your Honor, just to clarify, then the exchange will occur Sunday nights at Hall of Justice,
Yes.
or okay, not at daycare on Monday.
Right, because the parenting time ends Sunday at 5 p.m.
Right, got it. Okay, well, thank you.
Yep. So signed off on that. Then let's take a look at, there is a proposed temporary family law order. It's a 2-page order, Ms. Wolski. Basically, it's kind of a summary order, just says, hey, there's no money judgment. There was a motion for a family law order and a restraining order. There's no active military duty. It covers the care and safety of Mason. There's no fees ordered, and that there was a temporary protection order in another case that allowed contact in case of emergency involving the child. So any concerns or objections to that proposed order?
No, Your Honor.
Okay, that's pretty straightforward, so I'll sign off on that one. Next is a proposed protection order, and it's a 12-page document. Ms. Wolski, did you receive a copy of that?
I did, Your Honor.
Okay, do you have any concerns or objections to that?
No, Your Honor.
Okay, Mr. Foley, I'll go ahead and sign off on that as proposed.
Okay, thank you.
Your Honor, was that protection order against me, or is that the one that is still for me against him?
Yeah, good question. This order restrains Luciano Torres and checks Melissa Wolski.
Okay.
So signed off on that. Then let's talk a little bit about child support. I reviewed the documents that both parties submitted. Ms. Wolski, do you want to go first and just share your view of what your income is and what you believe Mr. Torres's income is and how child support should play out?
My income is around like $1,400 a month, maybe less. One check I got was $800. One check I got was $500. I'm not really sure. I submitted the pay stubs.
Yeah, so it looks like you're earning $19.51 per hour, correct?
And I'm maybe getting less than 20 hours a week right now with all of the children's appointments, my appointments and therapies and parenting classes and all the sorts of things I'm doing extra right now.
So your net's about $1,400 per month, correct? On average. Okay.
Sure.
Any input as to Mr. Torres's income?
His income is significant as he's working 2 full-time state jobs. Mm-hmm. I don't really know much about how much exactly he makes or what he has going on. So.
Okay. All right. Thank you. Mr. Foley?
Thank you, Your Honor. We pretty much spelled it out in my client's declaration. We're asking the court to basically just calculate child support based upon the state job that he has held for a number of years. The SSI job, as my client indicated in his materials, was taken solely to allow him to kind of catch up on debts and some back payments and things like that. As a matter of fact, Ms. Wolski had applied for benefits while they were still together. The state came back and said, no, you owe that money back. So he's also been paying that. So we're just asking that the court use the numbers that we had previously submitted for purposes of calculating and not include the the second job, because again, I don't know that that's necessarily going to last. He's had that since January of 2023. And now that they're separated, I don't see that there's going to be a lot of additional debt that he's going to incur. So once he gets this paid off, then it's my understanding he plans to basically just work the one job.
Thank you. So in his declaration, he says, "I'd like to secure the funds for that," meaning legal stuff matters.
Right.
I resign. So it sounds like his plan is to continue on there for at least a period of time, unspecified, correct?
Correct.
Okay. And then the figures that you provided, you've provided his gross at 96.54 per month and 74.46 net per month. Those are the figures you used, correct? In your worksheets, at least.
Right. Right.
Okay. And then you're asking that Ms. Wolski be imputed at full-time or imputed at 1951 per hour, 40 hours a week.
40 hours a week. That's correct. And that seems appropriate. If the second job is going to be considered, then it seems appropriate to impute at 40 hours a week.
And does his second job, is it subsumed or represented within the 96.54 gross and the 74.46 net?
Yes. That's my understanding.
Okay. All right. Ms. Wolski, any further input on?
Your Honor, I am aware that he has significant debt occurred from his criminal record. He monthly has to pay fines and fees that equal about $5,000. He has a Cadillac Escalade that he just got, and that is a significant $1,200 payment a month. He has a Cadillac or a Camaro SS he pays around $800 a month on. His insurance skyrocket. I mean, his debt is because of his choices, not because of anything that he's trying to pay off. It's because of his things that he's gotten since being with him.
Okay.
Well, Your Honor, my client spells it out in his declaration. I'll just leave it at that.
Thank you, Ms. Wolski. All right, so I'll set Mr. Torres's gross monthly income at 9,654 and his net at 7,446 for purposes of child support. As far as Ms. Wolski's net income and gross income, I'm going to calculate her net income to be at 1951 per hour at 35 hours per week. So I'm imputing extra hours that she's not currently working because it appears that she's underemployed at this time for various reasons. So that will set it at, I'm not exactly sure the exact figure. So that those figures of the 1951 per hour at 35 hours would need to be calculated and then placed into the calculator. And then combined with the 74.46 net of Mr. Torres, it'll come up with a figure. So that means we'll be back for another presentation for child support worksheets and orders. And I'll ask the parties what would be a good date and time for you all to come back. Mr. Foley, since you're preparing that order, can you give me an estimate of what would be good for you?
We should be able to be back in, well, let's see. I was going to say 2 weeks, but
it's the 26th. Well, court will be open, but.
Well, what's the court's preference? I mean, I certainly.
January 2nd is looking pretty good, or December 26th is looking fine, either one.
Oh, why don't we just go with the second? That's fine.
Ms. Wolski, would that work for you?
Yeah, that's fine with me. I have requested a guardian ad litem, and I will be sending that document over to Mr. Foley. So we will have court on the 9th for that.
9th of January?
Yes, yeah. So I'm fine with doing that on the 2nd.
I'm wondering, and this is just a proposal, if we're going to be back here on the motion related to the guardian ad litem on the 9th, would it be okay to do the child support presentation on the 9th also?
Yeah, that would be wonderful, actually.
Mr. Foley?
Okay, so I will change that to the 9th.
Yeah, let's do that. So we'll set the presentation child support for the 9th, and we combine that with the same 22-3-28508. Mr. Zandi is here representing Natasha Geis and Mr. Jacob Geis. I see him here also. Can you hear me, Mr. And you correct me on the pronunciation, please.
I don't know what the correct pronunciation of it is, but I think Geis is great.
Okay, we'll go with that. Sounds good. All right, so we're here for a review hearing. And let me just get my notes up. Related to, looks like we have the trial coming up the week of the 18th, and readiness is today at 11:30. Is that what I understand? And we're also here to review results from the 10-panel follicle test and
That's
update for witnesses and contact information and the like. So that's kind of what I'm expecting, and you all may have different expectations, so I'll hear from each of you.
And again, Your Honor, filling in for Ms. Bliss, who's over at the Hall of Justice on a different matter this morning. She gave me clear notes. We discussed about it this morning. My understanding is that, yes, you are correct. There is trial next week. And today's review was just to look at the hair follicle screen from Mr. Geis, sorry. And those came back clean, and visitation will resume. And we're ready to go to trial. I don't think there's any further issues that need to be resolved today, at least in my discussions with Ms. Bliss and the notes that she provided today.
Okay, thank you, Mr. Zandy. Mr. Geis?
well, I'd like the opportunity to be able to speak up on the matter of even the hair follicle in itself. Since the beginning of the divorce process and the custody hearing, I've gone to a treatment facility and had a drug and alcohol analysis done, and I was clean at that point in time. At the beginning of all this, I've submitted multiple drug tests, all being clean, except for I had submitted 2 that were positive for marijuana, which doesn't make me a criminal. I've never used any drugs in front of my children. I am a good father, and I love my children a lot, and I'm just being named as a bad person, and all for what? Because of hard feelings in a situation. And I don't quite understand why it's having to come to such a lengthy process, and just for me to be able to be a father. I understand that a relationship failed out of all of this, but it doesn't mean that I'm a bad person or a bad father. My children are very important to me. And so the accusations, nameless accusations, them not being true, and me having to defend myself for what reason. And I'm just disturbed by how it's a revolving door of me constantly having to say the same thing over and over again, where I'm not the person that I'm being called out to be. And it's kind of a painful process.
No doubt. I think any divorce proceeding is very painful, and it's disconcerting in a lot of different ways. So it sounds like the hair follicle test was taken, so I appreciate that. It came back, it's clean, there's no issues there. And the issues that remain in the case are going to be resolved at the trial, which is coming up. We'll find out today, the specific date and time, today at 11:30. So that's where much of this can be aired, and hopefully some clarity can be granted to the situation, and the parties can move forward. So I appreciate taking care of that hair follicle test, and any of those issues that are concerning. Obviously, those can be raised at the trial, and greater clarity can be provided. So with that said, I'll just invite both parties to be on the readiness docket today at 11:30, so you know the specific date and time that the trial will be set for next week. You can all be prepared and ready to go. Any
Very well. Thank you, Your Honor.
Okay.
Thank you.
Great, thank you. Mr. Zandy is present. He represents Alexa Marsh. Ms. Hoke is here. She represents Jake Swingle. And I think those are all the parties that are present for that case. So we're here to address review of visitation, and then there's some issues related to Quinn, the child, and the child's well-being, and potential surgery coming up, and some issues about travel and the like between the Tri-Cities and here. So we have the temporary parenting plan that was put into place with a kind of a phased approach, and it was set for review today. So I'm all ears to hear from the parties. There's not necessarily a moving party today, so I guess we'll just default to the petitioner, who is Ms. Marsh. So we'll hear from
Actually, I'll go ahead and defer, Judge, if that's okay with Your Honor, to Ms. Hoke. She filed a declaration before I got mine out, so it might stream a little bit cleaner if she starts, and then I give my 2 cents, and we can proceed from there.
Ms. Hoke, are you?
That's good for you, Ms. Hoke.
Yeah, that's fine.
Okay, have at it, please.
Good morning, everyone. Your Honor, I believe the transition has been going quite well. They've completed 6 months of that transition, and prior to that, there was some rehabilitation or some counseling for reunification. That went well. I think today there's a corner to be turned here, or I thought there was, but now we're in the position where the daughter has a serious medical condition and is going to require surgery. So I think we're going to need to work around that and possibly come back to this determination about a more permanent parenting plan once she's healed and is doing better. We certainly don't expect to have her transported to the Tri-Cities when she's recovering from back surgery. So, I don't know how Mr. Zandy feels about that, but if we could fashion something today, my client's been doing the visits here in Vancouver. If we can figure something out for the time being, it looks like maybe we would need another review date when she's on the mend from the surgery.
It sounds like there's still some workup that needed to be done before they're deciding when the surgery is going to happen, or the extent of the surgery and then the length of recovery. Sounds like that's still up in the air. Any further updates on that?
The letter says that the surgery is scheduled for January 19th. So
Right.
That could change, I suppose, but I think we're looking, at a month or so until the surgery. So,
Yeah.
but yet she's uncomfortable. So my client doesn't want her now, and that's part of why they're doing the surgery. He doesn't want her to be uncomfortable at all, but he does want to see her. It would just need to be closer to her home.
Right. Yeah. My impression was they didn't know the specific procedure, and therefore they didn't know what type of activity restrictions would be a result of the surgery. So there's still, it sounds like, more information that will give us a clearer idea of how long the recovery is going to be, I guess. Okay. All right.
She's been diagnosed with that tethered core syndrome, and I had to have my client educate me a little bit on that. And I did some of my own kind of independent research to see what that entails. And it is fairly significant. I think the information from Kaiser indicates that there's going to be ongoing MRIs over the course of the next couple of weeks to kind of pin down exactly what they're going to go in and do. But I think the procedure is pretty set. They know, generally speaking, which of course, I think a lot of surgeons will say you never know the extent until you actually get in there and look at it. I think that's kind of the approach they're taking with this. But all accounts indicate that this is going to be pretty significant recovery period, significant amount of time of missed school, significant amount of time of discomfort for, again, it's sad, a 7-year-old who's going to have to do this. Certainly surgery is never fun at any age, but especially for a 7-year-old child to undergo, that type of a process is painful. There's going to be a lot of at-home care provided. You saw specifically referenced in that doctor's notice, the caregivers for the child are going to be charged with a big responsibility of making sure she's moving, doing what she's supposed to be doing, getting the bathroom breaks and kind of working through that discomfort. So I don't disagree at all with Ms. Hogue. I think this is one that, although we have transitioned a little bit as of September into these overnight visits, albeit supervised by paternal grandpa. Where we sit right now, we've given you information from Hannah, the counselor, which kind of details that, although we've had these visits, there hasn't been any alarms. There's still a lot of work to be done on this. The child is still working with the counselor, still working with the medical providers on the back issues. Little girl has a lot on her plate right now. And Quinn, again, working through that, and time with dad, strengthening that bond, strengthening that relationship, certainly is a good thing. We're not asking to have any time taken away. We're just asking the court to be very thoughtful in the approach moving forward, because again, this is a father who, for one reason or the other, has been absent for an extended period of time and is still building that relationship with his child, which is a constant work in progress. We recognize that. But giving this child too much too soon, again, is always a concern that we have in these reunification cases. And that's kind of where we're at. My client would like to see the status quo remain. My client gives you her suggestion for the Christmas holiday coming up. Again, she's doing everything she can to ensure that this child, again, is spending appropriate time with dad. She's never balked at that. But that's always a tricky position, is what is the appropriate amount of time given the circumstances we have now. We just ask that we have a little bit of thoughtfulness to the process and where we're at and where this child's been and what she's about ready to go through. That's our suggestion. I agree with Ms. Hope that if we set again for another review in the spring, that would probably be appropriate. And then we can kind of evaluate where the child is psychologically and physically at that point, and always adjust from there.
Thank you. So if the surgery, we run with it happening on January 19th, what's the proposal of a kind of a general time frame of a review to kind of get an update? How did the surgery go? How are things looking? What's the expectation for recovery and the like? Would it be roughly three weeks, 4 weeks post-op?
I think that's optimistic. My thought would probably be closer to 8 weeks post-op. And again, this is just me doing WebMD, so I hate to say I'm one of those because you can only take that with a grain of salt what information you get. But I understand this is a multiple month type of recovery. She might be back to school. She might be doing things in a limited capacity. But I think this is probably one that if we set this 6 or 8 weeks after the surgery, just see where she's at to keep this on track, that would probably be appropriate. And in the meantime, I'll talk with my client about contacts, whether that's be FaceTimes or telephone or in person or what they're comfortable with. I would certainly ask for that because, again, you saw the term regression. We don't want this child to regress in my client's declaration. We don't want dad, again, to kind of fall by the wayside for a period of several weeks or months. I don't think that's beneficial to anybody either. So I think Ms. Hoke and I, the challenge will be figuring out if this surgery is going to happen, how long the recuperation time is, and what kind of contacts does this child have with dad in the meantime. Because as the information from Kaiser says, she should not be in the car for long periods of time. And my understanding is long periods is defined as brief as Kalama to Vancouver. That could be detrimental and uncomfortable. So again, we got to kind of work through that given the circumstances.
Go ahead, Ms. Hoke.
So I'm a little confused because I was under the impression she was being homeschooled, which might make it easier to continue her education during this time, or a tutor can come to the home. So I think that part of that can be addressed. The temporary parenting plan has the transition schedule that ended November 25th and provides for no additional time for my client with his daughter. So I would like to fashion something today, at least for some period of time, so that he's assured that he will be able to continue to see his daughter. And if it needs to be brief periods after the surgery, brief periods before the surgery, at least some ongoing in-person contact, I think is really important here.
Are there restrictions pre-surgery?
I haven't seen anything. They're just saying that,
Okay.
It could be difficult for her to travel. And we're not asking that right now. We would be addressing those issues when she's recovered from the surgery, but he would like to be able to come down and see her. I mean, I guess we could continue phase 3 for a period of time.
That would seem reasonable to continue that for a period of time, and then once the surgery hits, then obviously that would have to be altered. And then I'm thinking of February 20th. So that's 4 weeks from the surgery. At least I would think at that time there could be likely a plan, or at least some type of information where we could, and maybe just a quick check-in also on February 20th to see where she's at and what progress she's making. So that's my proposal, to review this on February 20th, Tuesday at 9 a.m. So let's set up a review on that date. Then there's a request from the mother related to Christmas Eve exchange as opposed to a Christmas morning exchange. The parties want to address that.
I guess that would mean, if they're just exchanging between Vancouver and Kalama, which is what it would be, because my client would be with his father, I don't think he would object to that.
Okay. Mr. Zandy?
No, and my client certainly understands it's Christmas Eve and everybody enjoys the holidays with their kids, or at least they certainly should, or that's the expectation. She has willingly extended that visit on Christmas Eve. I believe, without looking at the calendar, Christmas Eve this year is on a Sunday. That would be the return date anyways. She's just said extend that period of time that Mr. Swingle would otherwise have with Quinn, so they can start maybe some of their own holiday traditions. I think that's positive. I think that's good for everybody involved. But it also maintains the continuity for the child to be able to wake up on Christmas morning, enjoy Santa Claus or presents or whatever the traditions are in my client's family from there. So again, I think 8 o'clock exchange time on that Sunday, which I believe is the 24th, is certainly appropriate. It sounds like it's agreed between the parties, so all the better.
All right, so that does sound like it's agreed. So we'll make that an order that Christmas Eve exchange occurs at 8 p.m. And we will see everybody on February 20th and hope that everything goes super, super well for during the surgery and thereafter.
And in the
So you-
meantime, because this is a fluid situation, and surgeries can be postponed, they can be delayed for whatever reason. We'll keep kind of where we're at. We'll still have that date on the 20th, which I think is good. And then pending again that gap between January 19th, assuming that the surgery does happen on that date through February 20th, I will certainly work with Ms. Hope to see, based on the doctor's information, what's appropriate as far as visitation and how we can hopefully fashion that between those 4 weeks before we're in court between surgery and February 20th. So I think that's as good as we can do for now. I appreciate your time, Your Honor, and Ms. Hope. I think we can work with that.
Great. Ms. Hoke, any final comments?
I just want to clarify then the next visit is Saturday the 23rd until Christmas Eve at 8 p.m. and then alternating weekends after that. That's what phase 3 was, the alternating weekend. Otherwise we have nothing except the Christmas Eve visit.
So I had the schedule going back a few months, October 7th and the 21st of October, then November 4th and 18th, and then December 2nd and the 16th, and then Christmas Eve exchange, and then the 30th of December, I guess would be the next one.
Okay.
And then
So yes, still in phase 3
alternate.
at the grandfather's home from 10 a.m. Saturday to 10 a.m. Sunday, except for the 24th, which would be 8 p.m. because that's Christmas Eve.
Yep.
Yeah, that's good. That sounds good.
Fair
Thank
enough.
you for all your trouble. And thank you, Mr. Zandy.
Yep. Thank you.
Okay, thank you both. That'll complete the hearing for today. Thank you. And
Thank
I believe Mr. Harris, I see him on also the call. Can you hear me, Mr. Harris?
Yes, Your Honor, I can.
Okay, very good. All right, this is a motion brought by Mr. Harris related to the proposed reduction of visitation and supervision, kind of pretty much focusing on Mr. McFarland. So, Ms.
Your
Dow.
Honor, if I may, Your Honor, we have an initial objection to make.
Okay, go ahead.
Mr. Harris is completely ignoring local rules as to page limits. We're asking the court to strike the 17-page rebuttal declaration that was filed on December 4th and the 7-page witness declaration that was filed on December 8th. Those are way past the local court rules.
Okay, thank you, Mr. Harris.
Well, Your Honor, if we don't do this now, I'd ask we set a hearing of 30 minutes on universal schedule date.
Your Honor, that doesn't change the local rules as to page limits.
It's true. So the issue of page limits is important in that there's these page limits, they've developed over time, and I agree that it's when there's a lot of information to cover, it becomes more of a challenge to fit it all within the specified pages, but it's possible. And it's also important to take note and recognize that these are temporary orders that we're talking about. So these are pre-trial, before a trial, and then once trial occurs, then there's a more full and robust discussion and presentation of evidence. So related to the motion to limit the pages considered by the court, I'll grant that. I think it's appropriate. I think that I have the information that Mr. Harris wants to convey in the limits set by the local rule. So those pages beyond the local rule, I won't consider those. And I think I have a fairly good idea of what he's talking about and what he's concerned about. Any other preliminary motions, Ms. Dow?
Your Honor.
Okay. All right, Mr. Harris, I'll hear from you.
Okay, Your Honor. Well, first of all, I'm experiencing some difficulties with my camera, so I'm just going to be audio.
That's okay.
Before the courts, my motion for the temporary family law order filed on October 23rd for two purposes: to restrain Mr. McFarland from being around our daughter, especially during the respondent's visitation times indefinitely, and to reduce the respondent's visitation time to Saturdays for 4 hours to be professionally supervised in order to evaluate the parent-child interactions and relationship, to report to the court and myself any recommended need for family therapies. I prepared my presentation to read before the court to remain organized and timely, I ask for accommodation and patience. I estimate that'll probably take about 9 to 10 minutes.
Go ahead.
I originally filed for separation because the respondent abandoned her role and presence within our home and family as outlined in my previous filings for weeks on end over the course of several months, leaving me to work full-time to provide as well as take on all the duties of parenting. To keep it simple, my pleadings have previously referenced concerns of adultery in the context of how it played a role in the separation affecting the children. My sole focus has been on and will continue to remain about them. While I'm wholly aware this is a no-fault state, through my previous pleadings, I have clarified that I would object fully if discovering this man had played any role or proximity to our children at the time of those statements within the declaration. I simply iterated that there were serious concerns of care and safety in relationship to this man physically and legally, including with minor children. So it should not be surprising news that my actions have come before this court, and especially relating to care and safety concerns. On October 21st, after visitation as outlined within my pleadings to support this motion, I was made aware that my daughter was in proximity to this individual, Mr. McFarland. With credible care and safety concerns, I motioned the court immediately. This act was not abusive. It was not intended frivolously, and I acted upon this matter immediately and brought it before the court. The respondent continues to argue this is irrelevant to our case matter, and her limited scope of prevalence wrongly condones the proximity of this individual with our child. She, however, opened the door to the line through what litigation that I've presented within my filings by bringing Gerald McFarland into our case matter for her defense by means of declaration. To provide a clear and valid presentation, I took the liberty of getting records that proved otherwise, which I believe you just struck from the record, those 17 pages. But while the respondent argues that there's some feud between me and Gerald, I assert this is not the case. I've factually outlined my interactions, observations, and have filed with this court a declaration from Pastor Ross Wiley about the same. The exhibits I attached support my concerns, and care and safety are petitions for protection, declarations, and orders reviewed and heard before Washington State courts made by Gerald's wife, Carrie. The court's rulings supersede the opinion of the respondent and her supporting declaration made by Gerald as just hearsay and allegation.
Your Honor, I'm sorry to interrupt, but Mr. Harris is straying over into matters that were contained in the documents that have been struck from the record.
Noted, and I'll take that into account in listening to him.
Thank you, Your Honor.
My burden to prove that there are care and safety concerns has been met and is preponderantly clear in the evidence that has been stricken. Sorry. I ask the court order indefinitely that our children, whenever in the care of the respondent in the future, never be allowed around Gerald McFarland. My request before the court for visitations to be reduced as modified is brought before the court in main part of my observations and interactions, as well as the impressions brought before me from our minor child, Angel. The instability of the respondent is not deniable from even her own pleadings in relation to her living arrangements. While unfortunate for her, this does have an adverse effect on Angel when visiting her, as she is not engaged in a manner that promotes a healthy parent-child interaction. Angel has impressed upon me that she feels neglected during her visitations and that they do nothing of memorable value. When she comes home, she tends to have expletive-filled outbursts. As declared, this takes a few days to smooth out, and we have discussions about her feelings and what she desires. Recently, she informed me that on the day of the Longview parade that her mother was communicating with her about matters of the court and Gerald, as well as voicing her disgust in my significant other. This type of conduct, while not near the level of contempt, is concerning to me and interrupts the development of our child, especially in going forward with this matter. Collectively, what I've gathered and why I motion this request is that Jennifer is not fostering a healthy parent-child relationship and that the activities and discussions taking place are affecting Angel adversely. While she continues to argue that I'm alienating children, she neglects to outline her absent and limited engagements that seem to be doing the job for herself. If the respondent can prove to this court that this is taking place, I encourage her to motion for a GAL to investigate and interview the children. Otherwise, this should stop occurring, as it does no good for the resolution of this case. I can't afford counsel, yet through guided self-help resources, I've only motioned this court for a parenting schedule, child supports, contempt missed visitations, and now for temporary orders for the care and safety. To date, none of which has been admonished or fined by the court. This does not constitute abusive litigations by any definition. If the respondent feels this way, then she has just as equal a right to appeal any decisions honorably made. My actions, again, are not abusive, frivolous, or intended to incur her costs to rise maliciously as she falsely pressures. I believe this is draw grasp at portraying me as controlling because, as this court will note, I've never been accused of harming, harassing, yelling, or demeaning to the respondent within our marriage. And through her counsel only points at a controlling principle to my character, desperate to assuage her circumstances as being my fault, and doing what, in fact, this is far from the truth. Your Honor has every right to interview both of the children in my home and determine if there's any validity to the respondent's absurd claim. If my character is any concern or question before this court, I encourage the respondent to motion a hearing to argue, in particular, my fitness to parent. She can depose any number of people that will stand before and testify favorably to my children's development in my care, including my interactions. Thank you, Your Honor, for your time.
Thank you, Mr. Harris. Ms. Dell?
Your Honor, Ms. Harris has previously addressed her reasons for leaving what she describes as fairly poisonous atmosphere in the marital home. Her living situation is a direct result of having to leave their home with no assets and very limited income. We've addressed that question already. And the court has ordered a temporary parenting schedule that at the moment she cannot fully exercise because of her work schedule, but she is exercising her time. Her declarations point out the sorts of activities that she does with their child during the daytime visits that she has right now. Ms. Harris and Mr. McFarland have both provided declarations to the court about the issue that Mr. Harris seems to be most fixated on, which is what he imagines their relationship to be. My client's only peripherally aware of what may or may not have gone on in Mr. McFarland's divorce. All she knows is that he does have unsupervised time with his own kids. He seems to get along with them fairly well. He's not part of her life.
The pedophile, that dude, Rachel Booth. She come up.
Your Honor.
I'm going to excuse that person. I don't know who that person is. They've been excused. Thank you.
Thank you, Your Honor. Mr. McFarland's not part of Ms. Harrison's life. The only encounter the party's daughter has had with him was in a public place at an event that a number of people participated in, except Angel Harris. She was not allowed to carve pumpkins because her dad told her that she was not allowed to with anyone except him, her grandmother, or her older brother. So she refused to participate. She was upset about it. She was afraid she was going to get into trouble. My client didn't insist. She's sensitive to her daughter's feelings. She's sensitive to her daughter's needs. Mr. Harris is asking for all manner of restrictions on Ms. Harris, based primarily on his apparent obsession with Mr. McFarland. He's not taking advantage of the tools that the court has already given him for drug testing to confirm or deny the allegations that he's made against Ms. Harris. He focuses on a relationship that both people categorically deny. He's dragging someone who used to be a family friend, a friend of both of them, into his war on Ms. Harris. His own submissions admit that he is forming an alliance with Mr. McFarland's ex-spouse in their matter in Lewis County. This has nothing to do with the situation in front of this court, with the exception of some concern that the court might have that this child might encounter an individual in a public place. Mr. Harris has apparently gone so far as to tell one of their sons that Ms. Harris was having an affair with the son's Sea Cadet leader, Mr. McFarland. That apparently caused the son to drop a positive activity. It further alienated him from his mother. Your Honor, this is way over the top. We're asking the court to not only deny this motion, once again, we're asking for an award of attorney fees to help defray the expenses my client is incurring to respond to repetitive filings that focus on the same issues over and over again, regardless of the court's ruling on those issues or on the matters that are before the court. My client is working to establish a settled, stable, comfortable relationship with their daughter. She's kind of given up on the older boys. Within the limitations that she's experiencing, financial, the limitations on her time with the child, it's my understanding that she's been looking for other work, as the court suggested, and as she feels she needs to do, to improve her financial situation, which will improve her living situation, and will also give her hopefully weekends to spend more time with her child. That is something that we need to address elsewhere, as well as Mr. Harrison's verbal request here for a guardian ad litem. So today we're asking the court to deny this motion, award some attorney fees to help my client at least a little bit, and let us carry on with this. Thank you, Your Honor.
All right, thank you, Ms. Down. Brief rebuttal, Mr. Harris.
I disagree with her allegations that, I'm feuding with Mr. McFarland or being frivolous. I'm just concerned about the care and safety of my children. And, as far as the boys being alienated, well, I've told them nothing other than, people make bad choices and it is what it is.
Okay. All right. Thank you. All right. So here, Mr. Harris makes a motion to the court to restrict Ms. Harris's time with their child in common to 4 hours on a Saturday, professionally supervised, and that Mr. Gerald McFarland have zero contact with the child, the minor child. So what kind of struck me while reading this is that I think everybody approaches situations differently, and we all have our own colored up glasses, if you will. Our lenses affect our perception, and our perception is our reality. So Mr. Harris sees Mr. McFarland in a very negative light. He has concerns related to his interactions with his former spouse and also his child, and around interactions with other individuals at the church and the Sea Cadets and the like. So taking that into consideration, I find that there's an insufficient showing to impose the requested restrictions, and so I'm going to deny that. On to the issue of attorney fees. There was a significant excess filing of the local rules and limitations on that. And there was also a significant amount of hearsay contained within Mr. Harris's pleadings, where he recounted the statements of other individuals. So I think that's sufficient to impose $300 of attorney fees. So Mr. Harris will need to pay that to Ms. Dow. So I've denied that. I'll do a brief bench order that denies the requested motion. And I'll also include in there the $300 attorney fee award. Are there any issues, Ms. Dow, Mr. Harris?
I don't believe so, Your Honor. Thank you.
Okay, Mr. Harris, any final items?
No, thank you, Your Honor. I appreciate your time.
All right, that'll conclude today's hearing. Thank you.